The fact that in this case, the allegations that this is some grand conspiracy is insane to me. It's truly insane. I've practiced in this court for a very long time, and I've never had an attorney accuse me of what has happened in his pleadings, and I take great offense to it. I will continue, and as I always do, to follow my constitutional obligations and the obligations in the Michigan court rules with respect to discovery. But I can't create discovery where no discovery exists.
I will respond to that by saying, number one, I did not do anything unethical in when I filed, and I agree that I should have no more conversation.
Counsel, let me just say, when I read your motion to compel discovery, and you were giving this background information, I'm not going to opine on whether or not it's ethical. I think you have made certain allegations against people that if I were to call you to task to say that that actually happened, I think you might be hard pressed to do so. The very fact that people with the same last name exist in an office doesn't mean that they had anything to do with it. In fact, typically, certainly as it would be between Patricia Reiser and John Reiser, I'll just say this, maybe what you're saying happened. Maybe. But the ethics of these individuals, if one's going to question them, then you better bring it. And not just try to float out that somebody did this or did that. Because, and I'll make it very clear, Miss Patricia Reiser has practiced in front of me for years. No, for years. Her ethics are beyond reproach. The fact that I can tell you this and almost would bet my barker that if something came across her desk and it had to do with Scioto Township, and she knows that her husband is involved in Scioto Township, she'd have nothing to do with it. She would stop, would go someplace else, she would forget about it and never have a conversation. That's who she is, that's how she's practiced, that is everything about her. So when I'm reading this, counsel, I'm going to tell you I have serious doubts when it starts that way. But things can happen. And that's why I went to the file before we got here to figure out who had it. She didn't have it. Her name's not on it. And I don't think it's fair to make accusations about people, offices, how they operate, without being able to substantiate it. You tell a story that somehow or another somebody, after getting done reading this, here's what I've got to believe. I got to believe somehow in Scioto Township, there is somebody who went to the sheriff's department, made some complaint that the sheriff's department then, without any basis whatsoever, then put together a report that they submitted to the prosecutor's office based upon their investigation, and that it didn't have, that there was no basis there to do anything, that then it got into the prosecutor's office, and the prosecutor's office then said, well, we don't see anything here, but we're going to make this happen. Wouldn't happen here. And that's really how your document reads. Go ahead.
I was gonna say, I apologize that it reads that way. You have to, if you would just see it from my perspective, I'm coming into this case, I don't know Miss Reiser, I don't know any of the players, all I know is what I'm seeing, and I see a woman who was part of essentially just an IT issue, and she ends up getting charged.
But counsel,
it makes no sense.
and maybe it doesn't make any sense. Maybe somebody made a bad decision in terms of their discretionary call. That's totally different from saying you shouldn't have done this to that there is this intentional thing to happen to charge your client. I'm having a hard time believing that. So while you may have absolute faith and belief in your client, which you should, that doesn't mean we create a conspiracy as to why something happened. Somebody may have made a bad call. Okay.
I 100% agree. I only wanted to give you the players and what their roles were. That's all I was trying to do, where people were and why it seems fishy to me. This case seems fishy, Judge, and I want to know if there's any shenanigans. I want to know if there's shenanigans in emails or texts between witness Hathaway and the sheriff. That's what I want to know. If they don't exist, then the prosecutor can just say they don't exist. I guess that's what he's saying. So I'll take his position as, unless he wants to change it, as being, I've checked with the sheriff and these exculpatory documents don't exist. If that's the case, fine, so be it. That's the record and I will say nothing more. I appreciate the court's time today. And again, I did not mean to be disrespectful in any way.
So, because I'm not going to go through this again.
I don't want
Because, no, listen to me. You know, counsel, sometimes I want to just take attorneys back and just have them understand that in the privilege to practice law in this state, you need to be respectful of the process and the people. And you have to do it in a way that doesn't practice in a way that doesn't jeopardize your credibility. And I think people don't do that. And sometimes they don't do it with just the words they use. You know, Mr. Childers gives his response to your motion. I can tell you, I appreciate, I guess, Mr. Childers' discipline and how he responded, because I think if certain accusations had been made against me in my office, mine would have been a little bit more fiery than that. But that's just me. Do you have a copy of your reply?
I sure do. Would you like to? May I approach? Oh,
No, I've got a copy right here.
Oh, sorry.
I've got a copy right here. I want you to just follow along with me.
absolutely, sure.
In your reply, that it's their 11th hour filing of its response to your motion to compel. Really?
Yeah, it was filed last night or yesterday. I filed it weeks ago.
What's the need to say that? I'm going to know exactly when it's filed. What's the purpose behind that, counsel? Really? To say that somehow they were dilatory in what they needed to do and just sort of threw that in? I mean, really, what's the purpose in that? Then go to the next
Can I
paragraph.
just answer your question?
Go
The
ahead,
purpose
if
is
there
to
is
explain
one.
why this was short and done in the last minute.
Counsel, I know when everything comes in. So, and then you make the pejorative statement in the next paragraph, counsel. That the people shrug off their constitutional responsibility to locate and produce potential Brady material.
In this tense courtroom exchange, the judge sharply challenges a defense attorney's accusations of misconduct and conspiracy within the prosecutor's office. The prosecutor first rejects the claims as baseless and offensive, insisting no hidden evidence exists to produce. The judge then steps in, warning the defense that serious allegations require real proof, not speculation. He defends the professional reputation of the officials being accused and cautions the attorney about damaging credibility. The moment becomes a clear judicial reminder. In court, claims of wrongdoing must be backed by solid evidence, not suspicion.
Did they really do that?
Yes,
Then counsel, why do we get to the point today after this hearing? What have they shrugged off? List it to me. No. If you're gonna stick by that statement, list it to me.
Yes. It's constitutional duty, and I'll quote.
I know Brady upside down and backwards.
Sorry.
So you don't need to quote it to me.
But they shrugged it off because they said, I don't know about it. They didn't check. They didn't look. They didn't become educated, as far as I know. Maybe they did. And I'd like to know that. If that happened, then they didn't shrug it off. But right now it looks like they did. Looks like they shrugged it off.
Even now?
Mr. Childers has still not said that he checked. He still has not said that he.
You have got to be kidding me, counsel. Even now.
Did he check for emails? Can I just ask him?
But even now, counsel, you sat down. Mr. Childers gave his response about what he would do. You sat down and you said, okay. I then read something that you wrote, and you're still maintaining that somehow or another they're not abiding by the Constitution in some way of jeopardizing your client's rights. I'm going to tell you, and I will assure you, counsel, in my court, your client's rights will be protected. And quite frankly, that is in regard to any attorney or whatever. Even if the attorney's not doing their job, I'm going to do my job and make sure her rights are protected. So but after we get done with all of that, you still are sitting here saying that he's shrugging off his constitutional obligation, counsel.
You asked, I thought your question was, why did I put it in there? Right now, if he's checking, then I'm not saying that. I do not still think that. Is that your question? I'm sorry. I thought you were asking me why I wrote that. Sorry.
Yeah, well, I still am curious as to why you wrote it, because it's not true.
I disagree with you. I'm sorry.
Show me where it's true.
I just disagree.
No, show me where it's true. If you want to disagree with, you know what, counsel? The way I work, if you're going to say it, you're going to be called upon to put up or shut up. Show me where it's not true. Now.
The prosecutor did not educate himself as required by constitutional law by going to the chair, finding out if there were emails. I know there are emails. I know they exist. And for him to say they don't exist, it's not true. So there's emails. So I know that's not true.
He's not in possession of any emails. He doesn't know that they. Counsel, I've asked you what emails exist. Your emails, or your knowledge of these emails, supposedly come through basically 3 levels of hearsay as I count. And so the thing is, when I ask you, tell me what you want. When was it? What are they not giving you? You can't give me anything.
Your Honor, I know what I know, and I explained how I knew it, and that's all I know. Okay, so I'm asking though I was asking for a general.
Counsel, that's not the way I practice in my courtroom. If you come here, you better be ready to answer my questions and put forth what you're saying. I don't operate on speculation of something. If you're telling me that the people have something in their possession or have access to that may be exculpatory to your client, certainly, but even if it's inculpatory and they haven't given it to you, you need to lay that out to me on something other than speculation about whether or not something exists. That's the way I work.
How would I know? How would I know if it exists? If I don't have.
And you just can't make the accusation, counsel, that they're hiding something.
I'm just asking. I wasn't saying they're hiding it. Asking for the information.
No,
Sorry if I,
your whole motion is an accusation, counsel.
I don't read it that way. I'm sorry. It is an accusation. No, it's an accusation
That they shrugged off their constitutional duties to produce certain evidence that they don't have, and you don't know if they have it or not. I mean,
I'm asking for it. I'm just trying to compel it. If you don't compel it, then I'm the one never.
what are we going to compel?
I would ask for an order saying, turn over any emails if they exist that are exculpatory. That's all. If they don't.
Counsel, that is about as useful as turn over every unicorn in your possession. Because I don't know that they have either one. I mean, that's not a basis of a motion to compel, counsel. That's not how you practice. If you, and by the way, counsel, some of this you can FOIA, you can subpoena it. But you also have to do your job. And if they're not turning over something and you truly believe that they're not turning over something, then fine, come before the court. But be prepared to tell me what they haven't given you. Don't give me some conspiracy story. Don't give me all of these things. Don't say because something's politically charged one way or another that all of a sudden makes it something, because that makes no sense to me. You tell me what you want. If you think they're not giving you a direct answer to exactly what it is, then yeah, come here, I'll ask them. And they know I'm going to ask them. And then you can go from there. But you can't just throw everything up in the air saying they're not doing something when in fact that's not true. And here's the other part, counsel. The other part to this is, until Mr. Childers said so, because I didn't see it in any of the documents, this all starts from something you gave them. I mean, so you give them something, they fulfill their duty and obligation to try to follow up on it. And while they're in the midst of doing that, you do this. Crazy. That makes no sense to me. Why wouldn't you just wait? Find out if there's a report. If there's references to communication, then certainly one.
In this heated moment, the judge directly confronts the defense attorney over serious accusations that prosecutors ignored their constitutional duty to disclose evidence under Brady. The judge pushes back forcefully, demanding proof rather than speculation. He points out that the attorney cannot identify any specific emails or evidence being withheld. Instead, the claim appears based on layers of hearsay. The judge makes his position clear. In his courtroom, Accusations of hidden evidence require concrete facts, not assumptions or conspiracy theories.
Might be able to get those communications. But I'm not one that believes in a lot of conspiracies. But counsel, in as much as I want to believe, or you want to believe, that the prosecutor's office is running around trying to figure out how in the heck can I get at Miss Carey, why wouldn't I believe that you're giving them that document from the expert, having them go on what may be a fishing expedition, and then filing this motion is somehow and or another your attempt to try to make them look bad? Why wouldn't I think that that's the conspiracy you entered into?
If you knew my reputation, like you apparently know Miss Reiser, you would know that I wasn't trying to pull it.
Maybe then I operate on the presumption that people are acting in good faith until they show me something different. And that's why I don't go there to think that it's some kind of setup. I think you just messed this one up, counsel. I think you messed it up. And I think what you need to do is you need to make sure to wait for that. See what it says. The court will give you the time to analyze it, look it through. If there's a reference to some communication, then there's something there that says that it happened. But I don't have anything now. What day is this set for? The motion to compel discovery is denied. Mr. Childers, please prepare an order to that effect. Submit it to the court. As to the probable cause hearing, where do we need to go from here?
I think we should probably set it for another PCC and a probable cause hearing.
How much time did you need?
Well, I kind of understood from Mr. Childers that they're still analyzing the motion. And now we need to say.
I don't think that's what he said. I think what he said is he's going to be analyzing information and they'll be looking at it all the time.
Judge, are you going to be handling the probable cause hearing?
I will be handling the probable cause hearing. And whether or not it stays with me for exam is yet to be determined.
Okay, thank you.
Probable cause conference in this matter will be adjourned to November 26, 2024 at, was that? Pardon?
Those are at 9 a.m.
At 9 a.m.